So why did the court come to this decision? As I said earlier, I felt that the outcome was completely predictable. And as I thought about it again in terms of tonight, while preparing for this, I thought about the Sonia Sotomayor proceedings. And I thought about how there was so much emphasis on how her life experience was going to inform her judicial philosophy. And as I was Googling various things, I came across Professor Lani Grenier of Harvard Law School, who had a really cogent analysis of the Sotomayor nomination process. She wrote, biography may affect the facts that judges choose to see, and that, quote, indeed, cognitive psychology and history predict that every justice acts from a perspective. And I think that's exactly what happened here. If you look at the background of the three justices who were in the majority, all three are pillars of the legal community, and I say that with enormous respect. One has spent his entire legal career in a white shoe law firm. One has an enormous passion for history and deep veneration for a historical figure. And one came out of politics. Nothing untoward, nothing nefarious, but all very, very traditional. All steeped, I imagine, as I was growing up, in Civics 101 that says there are three separate but equal branches of government. No room in there for an upstart commission that's a mere 20 years old that has power. As they say, and they say that in their decision, they say, we cannot accept an invitation to read into the Ethics Amendment an unexpressed repeal of such an ancient and venerable hallmark. They just couldn't do it. So you have three traditionalists who are weighing a very ancient, venerable constitutional provision against the very recent constitutional provision, and one that is unique in the country. There is no other provision like Rhode Island's. So to accept that the ascension of the Ethics Commission would have required that these traditionalist justices think creatively, forge in the path through uncharted territory, and break out of the box. And that is simply not within their cognitive psychology. Couldn't do it. The justices in the Irons decision declined to become part of Rhode Island's ongoing lively experiment. They instead put a halt to the 1986 Constitutional Convention intended to create. It was predictable, but still disappointing. And as a postscript, I want to say bravo to Chief Justice Sutel for his very brave and compelling dissent.
Okay, now I want to take just 10 or maybe 15, depending on how many questions there are, for questions specifically about the case. And then we'll hear a few remarks and move to sort of what should we do in the future. I have the microphone and I'm going to hold it and for people that want to ask a question but not give a speech. Questions? We have no questions. Really? Okay, excellent. Oh, I know you want to. Is the red light on? If the red light's on, it's on. No. Oh, I'm sorry. I didn't push it hard enough. Now the red light's on.
What would you say to the argument that Bill Irons' use of his public office for private gain didn't count as a core legislative activity? If the purpose of being a legislator is to represent your constituents, what he was doing in this case wasn't, in fact, a legislative activity. What would you say to that argument?
And who are you asking?
I guess everyone.
Okay, Barbara, you want to start?
Well, I think the U.S. Supreme Court and the Rhode Island Supreme Court have been pretty clear that anytime you are voting on legislation, that's a core legislative activity. So as much as I want to say, yeah, you go girl, but it's just not the case. The law is pretty clear.
Yeah, I would also say, because the opinion made it clear. I mean, the speech and debate clause is a very important clause, and its original purpose was to protect legislators from being attacked by the other two branches of government, by the executive and by the judiciary. It also, over time, also came to include private actions by private citizens that might sue them for that. And the whole idea of an immunity is so that they don't even have to go through a suit, the problems, the expense of going through a suit. And in the kind of hypothetical that you proposed, you'd have a whole lawsuit about whether or not he actually was, in fact, representing the wishes of his constituency. Maybe he was, maybe he wasn't. Maybe part of his constituency approved of the actions that he was taking. I would, since I started talking, I would like to have an opportunity to kind of talk about some of the things that Mark said, because one of the things that he said struck me, because he said that the balance that was struck in this case, the whole issue really was the speech and debate clause is very important. And whether or not you think it should be repealed or not repealed in favor of the Ethics Commission or some other thing, that's an issue that we have to face now, whether it's a good idea or not a good idea, and whether we should scale back on it or not. But that question, I think, was already answered in 1986 at the Constitutional Convention, because the whole really issue in the case was what did the framers and the voters, the ratifiers, intend when they adopted the Ethics Amendment. And I think the history goes back even further than 1986. When you look, I think, as Barbara mentioned, the United States Constitution has a speech and debate clause in it. So does the Rhode Island Constitution. But there's a clause that hasn't been talked about at all here that I think should have been part of the conversation, and that is the discipline clause. In the Rhode Island Constitution, it's 2 sections after the speech and debate clause, and essentially permits the House to basically discipline its own members, and for the Senate to discipline their own members. In the early 60s, the Congress, the United States Congress, both the House and the Senate, developed their own internal codes of ethics. They developed their own standing committees that would investigate ethical violations. But in 1976, the General Assembly, instead of doing that, took a different route. They enacted the Conflict of Interest Act. That Conflict of Interest Act had a specific provision in it that applied to legislators and their core legislative activities. And I think that that was specific intent, that that act was intended to cover those core legislative activities. And when you look at the 1986 convention records, one of the things that the Ethics Committee members wanted to do was to make sure that they maintained what they had in the Conflict of Interest Commission. They did not want, quote, a watered-down Conflict of Interest Commission. And then immediately after the amendment was passed in 1986, the General Assembly enacted legislation to implement the new Ethics Amendment, and they adopted a statute that was virtually identical to the one that existed from 1976 to 1986, that basically said that if you're a legislator and you have a potential conflict of interest on a matter that you're going to vote on or work on or debate, you have to file a statement with the Ethics Commission and with the presiding officer of the House saying why it's okay for you to vote. That was specific, I think, evidence that at that time they understood, the General Assembly understood that there was going to be jurisdiction over core legislative activities. And that is something that other courts look to determine what the intent of an amendment was, what type of legislation was implemented afterwards. That's not part of the court decision. That's not part of the conversation here. And that statute is still on the books now. It stayed on the books for the last 22 years through 2 amendments of the Constitution in 1994 and 2004, and it's still there. I think that that was very valuable evidence that they could have looked at to determine what the intent was at the time.
I just want to, everything in life flows downhill, so now time got to talk about me, so now I get to go. I think it's too easy and not right or accurate to dismiss this decision as reflecting sort of 3 aging traditionalists who couldn't sufficiently think outside the box. I think many of us in this room know who those 3 gentlemen are. But don't forget, they affirmed a decision by Judge Derrigan in the trial court below, who also agreed with them.